Mr Chair.
I call the member Chris Hipkins.
Thank you very much, Mr Chair, and I'm very happy to take my speech on the title and commencement provisions of this particular legislation, and I want to pick up a point regarding a technical issue that I raised with regard to the schedules last week, and I want to particularly refer to Clause 3 of the bill, which refers to the Principal Act. This Act amends the Employment Relations Act 2000, and then in brackets the Principal Act. And the reason that I raise this is during the committee stage we had I had a bit of an interchange with the Minister about some circular wording in a later clause of the bill and the schedules of the bill, where instead of referring to the Principal Act, the wording has actually been changed in the Select Committee to now refer to this Act rather than the Principal Act. And the reason that that's important is if you take, for example, there's a provision on page 64, number 6, which says Part 6A of this Act, as it was immediately before the commencement of the 2013 Act, continues to apply to the restructurings as if the 2013 Act had not been passed. Now, the reason that that becomes significant is if this Act is interpreted to be this Act that we are now passing, then that simply makes no sense whatsoever. It becomes completely circular, and basically it's a double negative, cancels itself out. However, if this Act is taken to mean the Principal Act, then the clause actually makes sense, because it basically says that the Principal Act will continue to apply as if this bill or this Act that we are now passing hadn't been passed. But the question therefore becomes, if we're talking about the Principal Act in one part of the bill and we're talking about this Act in another part of the bill, that becomes slightly confusing for many people involved. And I thought our objective in this House was to try and start drafting law into plain English rather than something that you need to have a law degree in order to be able to follow, because it's incredibly complex. So the Minister did reply to the comment, although even then I'm not entirely sure that he quite understood what his answer was, and in fact he admitted that he didn't quite understand it himself, but that he had been advised that that was the right thing to do. So at least he was honest about saying that he didn't understand what he was doing, and that he had been advised that that was the right thing to do, and I commended him for at least taking part in the debate, which was very good. I think that that's a drafting issue that I think at some point in time in the future someone from the Parliamentary Council Office may like to provide some guidance to the government to get a greater degree of consistency in that, because it seems to me that we should be, well, like I said, consistent right throughout the bill. The second point that I want to raise relates to the commencement provision, Clause 2 of this legislation. And it comes into force 4 months after the date on which it receives the royal assent. And this is a very topical issue because, of course, well, it's kind of topical. I'm about to make it topical because the royal assent, of course, has a degree of royal prerogative within it. The head of state could refuse to sign this particular piece of legislation if they so chose. Now, it has never happened in New Zealand's history, but technically it could happen. That in reality, in New Zealand, it's, of course, the Governor-General signs the acts on behalf of the Queen, but the Governor-General or the Queen could refuse to assent to legislation, and therefore it would never come into force. As I said, that's never happened. Now, the reason that I say it's topical is, of course, it's what falls within the bucket otherwise known as the reserve powers of the head of state, and the last time in Australasia that the reserve powers of the head of state were used, it was used by the then Governor-General of Australia to remove the Prime Minister and the then Parliament, Gough Whitlam, who passed away last week. And so it is, of course, possible that the head of state or the Governor-General acting as head of state can use reserve powers, and therefore this bill, like any other bill that gets passed by the Parliament, could technically never come into force if the head of state so chose to refuse royal assent. And there is actually a reasonably recent example of where that has happened, not in New Zealand or Australia, but in fact in Belgium, where the King of Belgium refused to provide royal assent to a piece of legislation that was a conscience vote. I think it was either homosexual law reform or gay marriage, and the royal assent was refused. And there in Belgium, the parliamentarians used a very little known power that they also had to effectively depose the king for a period of time. In this case, I think they deposed the king for about 24 hours. and the Prime Minister was then able to sign the legislation instead. I haven't quite finished yet, Mr. Chair. And the Prime Minister was then able to sign the legislation instead. Mr. Chair? Mr. Chair?
Called Dr. Megan Woods.
I felt robbed.
You were robbed. Thank you, Mr.